This is Dalia Ramiro, Spanish interpreter on the line, already sworn in today.
All right, please connect with the headset.
One moment, Your Honor. Thank you.
Thank you.
Sí, sí, la puedo escuchar.
He can hear the interpreter, Your Honor.
Sir, please tell me your name.
José Ramiro Robles Zamudio.
Jose Ramiro Robles Zamudio.
You're here in 21 CF 14999, charged with battery by strangulation, domestic violence. There is probable cause. At this time, I'll appoint an attorney to represent you. There's not a witness out there, right? Okay.
No, Your Honor.
I just saw him standing by that door and I wanted to make sure. Sir, at this time, your bond is $10,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Sí.
Yes.
You can't possess or consume any alcoholic beverages. You'll be subject to random alcohol screens. You must maintain a separate residence from the victim. I'll allow a one-time return with law enforcement to gather your belongings, but you may not coordinate that with the victim. You can't possess a weapon of any kind, a firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
Your Honor, he does qualify for pretrial release. Would you consider putting him on pretrial release and reducing the $10,000 bond? He has no history.
I see that he has no history. I see that he's also not from this area, in fact, not from this country. And the court is concerned with securing his presence for future court dates, as well as the violence in this immediate case.
Here, it looks like he's been, I know he's not a citizen, but it looks like he's been here for over a year, Your Honor. Looks like his current length of employment is 3 years.
What says the state?
Your Honor, state has no objection. You place him on pretrial release with a slightly lower bond. The state does share the same concerns and support regarding his community ties.
At your attorney's request, sir, I'll reduce that bond to $5,000. With pretrial release, all of the same conditions will still apply. Good luck.
Gracias.
Thank you.
Good morning, sir. Please tell me your name.
Javier Herrera Chávez.
Javier Herrera Chavez.
You're here in 21 MM 772, charged with battery domestic violence. There is probable cause. At this time, I'll appoint an attorney to represent you.
Okay.
At this time, your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Oh, sí.
Oh, yes.
At this time, you can also have no contact with the
Tampoco
witness.
puede tener contacto, comunicación ni con la víctima ni con los testigos.
So you're now in the overhead.
I am.
Yes, if you could reconnect to the headset. I don't know what happened.
I have no idea how that happened, Your Honor. This is.
Sí, ya.
All right.
Okay, thank you. Sorry about that.
That's okay. Technology. We can't live without it, but sometimes it's Interesting. All right, sir, you also can have no contact with the witness in this case. You can have no unsupervised contact with any minor child under the age of 18. You must comply with any plan set in place by DCF. You cannot possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Sí.
Yes.
Good luck, sir. I believe that's all we have for Spanish at this time.
Thank you, Your Honor. Have a great day.
Thank you, you as well. Good morning, this is Judge Gibson. Who do I have on the line?
Portuguese interpreter Angela 202758.
Has the interpreter been sworn?
No, I have not.
Please raise your right hand to be sworn.
Do you swear to translate from Portuguese to English,
Okay.
English to Portuguese, testimonies given?
I'm sorry, did someone say something? I could not hear.
Yes.
Do you swear to translate from Portuguese to English, English to Portuguese, testimonies given?
Yes, I do.
All right, thank you. Good morning, sir. Please tell me your name.
Alan Silva.
Bom dia, senhor. Por favor, o seu nome.
Alan Silva.
Alex Silva.
Sir, you're here in 21 MM 8226, charged with battery, domestic violence.
O senhor está aqui na M1226, está sendo acusado de violência doméstica.
Yes.
There is probable cause.
E tem causas que são prováveis.
I'm going to appoint an attorney to represent you.
Eu vou designar um advogado para representá-lo.
Your bond is $500.
A sua fiança é $500.
With special conditions, you can have no contact with the victim or any witness in this case.
Com condições especiais, se você não pode ter nenhum contato com a vítima ou qualquer testemunha que vai testemunhar nesse caso.
You can have no unsupervised contact with any minor child under the age of 18.
Você não pode ter nenhum contato com qualquer criança com menos de 18 anos sem ser supervisionado.
You must comply with any plan set in place by DCF.
Você tem que concordar com qualquer planejamento, você tem que se comportar de acordo com o planejamento combinado pelo TTS.
You must maintain a separate residence, and I'll allow one-time return with law enforcement to gather your belongings.
Você vai ter que procurar uma residência diferente, vou permitir que você volte lá uma vez com a presença de um oficial para tirar alguns dos seus pertences, para você poder recolher alguns dos seus pertences.
You may not coordinate that visit with the victim.
Você não pode coordenar essa visita com a vítima.
You can't possess a weapon of any kind, firearm, or ammunition.
Você não pode ter possessão de nenhuma arma que seja, sabe, funcionando, né? Que seja realmente com balas.
And upon further review of this narrative, at this time, I'm actually going to raise that bond to $1,000.
Bom, revisando aqui o ocorrido, estou aumentando a sua fiança agora para $1.000.
Again, I'm concerned about securing his presence for future court dates, given the fact that he has limited local ties and is not from this area.
Eu estou só garantindo que o senhor vai comparecer nessa audiência na corte, já que o senhor não tem muitas conexões nessa área e não tem muita razão para ficar nessa área. Eu só estou garantindo que o senhor compareça.
Good luck, sir.
Boa
have a
sorte,
word?
senhor.
Can I talk?
Can I say a word?
Sir, you can say anything you want. Everything you say in this room is being recorded and can be used against you later. Do you understand that?
O senhor pode dizer o que o senhor quiser. Eu só tenho que avisar o senhor, qualquer coisa que o senhor diga nessa audiência aqui nessa corte está sendo gravado e pode ser usado contra o senhor nas suas audiências. O senhor entende isso?
Can you please advise the client that I would recommend he not talk about the facts of the case?
Eu recomendo que o meu cliente não fale sobre nenhuma coisa relacionada a esse incidente.
Yeah, just a question. I have no right to my defense because
Sir, I can barely hear you.
Eu não estou ouvindo o senhor.
All right, good luck, sir.
Boa sorte, senhor.
I believe that's all we have at this time for the interpreter.
Thank you for using our services, Your Honor. Have a nice day.
Thank you, you as well.
Thank you.
Morning, counselor.
Good morning, Your Honor. Blaine McChesney on behalf of Curtis Barlow.
Hold on a minute, I don't have that one. Oh, here it is. This is 21 MM 8217. Mr. Barlow, you're here charged with battery, dating violence. Counselor, did you wish to be heard?
Yes, Your Honor. This was an allegation of some pushing. There's no prior criminal history from my client. This is an isolated incident. The victim is present and would like to testify.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name for the record and spell your last name.
LeBron Estevez, Alicia.
All right, I'll allow the prosecutor to ask questions.
Good morning, ma'am. What is your relationship to Mr. Barlow?
Girlfriend?
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Of course.
Do you believe drugs or alcohol were involved in this incident?
Alcohol?
And do you want to have contact with him while this case is pending?
Yes.
All right, thank you. Is there anything else you'd like to tell the court? All right, thank you. That's all I have, Your Honor.
All right, any questions from the defense?
One more briefly. You also reside together, at least temporarily?
Yes.
And would you like him to return to that joint residence?
Yes.
No further questions.
All right, first, there is probable cause. I reviewed the affidavit. Any argument from either party on bond?
You know, Your Honor, my client is a resident here in Orange County. He's not really a flight risk with no prior criminal history. We would ask that he have just simply no hostile contact, return to the residence, and while we kind of sort this case out. And he is able to make a bond, but we would just ask for a very reasonable bond given his contacts in the community.
Anything from the state?
Your Honor, I understand victim's testimony today that she would like contact. State's only concern is the alleged threat that was made within the affidavit. I'll leave that within your discretion whether to set no contact or no hostile. State has no objection to a reasonable bond as he's otherwise entitled to it.
All right, sir, your bond is $500. With special conditions, at this time, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am. Yes, Your Honor.
You can't possess a weapon of any kind, firearm or ammunition. I reviewed the affidavit, and in the affidavit, it alleges that you threatened to kill the victim and her friend with your firearm. It appears you have 3. So I'll give you 24 hours upon your release to surrender those firearms. Do you understand?
Your Honor, they're all not all my firearms. I only possess one.
The other one is his roommate's and belongs to the roommate.
You can't be in a place where there's firearms
Yes, Your Honor.
because you can't possess a firearm, and there's such a thing as joint and constructive possession in the state of Florida. So you're gonna have to talk to your attorney about where you can live, but you can't live in a place where you have access to firearms. Do you understand?
Yes, Your Honor.
You must maintain a separate residence from the victim. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim and you cannot live in the same place. Do you understand?
Yes, Your Honor.
You can't have contact with any witness in this case. Are there any other conditions the state would request?
No, Your Honor. I believe the victim testified that there was potentially alcohol involved. However, I don't see that mentioned within the affidavit.
I didn't see it in the affidavit. It does say something about an after party, so one can assume there were alcohol and other substances, there was alcohol and other substances involved, but it's not in the report. Well, I'm gonna leave that. All right. Good luck, sir. Thank you, counselor. Good luck, ma'am.
Thank you.
#21 MM8150. I'm gonna appoint your office, Ms. George.
Your Honor, I'm gonna waive the appearance. It was reset to see if he would come, but there are, I don't know what happened to his out on bond case, Your Honor, but on his 2020 MM5168 AO case, it appears we were gonna have him evaluated and then it closed. I can't see why it closed, but that was back in September. He has multiple Baker Acts, so I just ask that you take all of that into consideration and not revoke his out on bond.
I do believe he most recently was Baker acted on 11/8.
All right, I'll stay the bond at $500, not return to that 7-Eleven. And I'll take no action on the out on bond cases based on those representations. Thank you. Good morning, please tell me your name.
David Jones, ma'am.
Mr. Jones, you have two cases. You're here in 21 MM8234, charged with violation of a domestic violence injunction, and 21 CF 15007, charged with burglary of an occupied dwelling, tampering with a witness to hinder communication to law enforcement, and criminal mischief, damage greater than $1,000. There is probable cause in both of these cases. I'll appoint an attorney to represent you in both cases. Give me one moment. All right, at this time, your bond on the burglary charge will be $20,000, tampering will be $5,000, criminal mischief will be $1,000. With special conditions, you can have no contact with the victim. Previously, a court had issued an injunction telling you that you could have no contact with this victim. I'm going to explain to you in detail what no contact means to ensure that you understand what I'm ordering. You cannot call her on the phone. You cannot send a text message. You cannot speak to her in public. You cannot be within 1,000 feet of her residence. You cannot send a message through friends or family. You cannot send a message to her through social media. Do you understand what no contact means?
Yes, ma'am. Can I say something?
Sir, you can say anything you want. Everything you say is being recorded and can be used against you later. Do you understand that?
She's not supposed to.
Listen. Thank you.
You can't possess a weapon of any kind, firearm, or ammunition. In 21 MM8234, again, there is probable cause to believe that you violated the domestic violence injunction. At this time, you'll have no bond on that charge. I find that there are no reasonable conditions of bond which this court can place on you with which you'll comply.
Your Honor, I would ask that you set a bond in this case. I was looking at his history. I don't see a history of violating the court's orders. It appears this is his first incident where he did allegedly violate the no contact order, and it was just issued in May. So I would just ask that you do set a bond here. He doesn't have a history of not following the court's order. This is his first offense for violating a domestic violence injunction. I would ask that you give him a bond and you can also place him on pretrial release, so he can be monitored. And if he violates, he can also be brought back here before you, and held at no bond. But he had 0 failures to appear. And his last offense was a driving while license suspended. But other than that, I don't see any other domestic violence violations.
I show that he was arrested for battery on this domestic violence on the same victim and that he's previously violated probation.
I was looking at I was talking about violating a domestic violence injunction, Your Honor, not the BAT DV.
I understand. I'm just saying in his history, he has a prior history of battering the same victim. A violation of probation is a violation of a court order, so he does have a history of that as well. And in this case, the fact that a court ordered him not to have contact with her and not to go back to the residence, and he did, and it says she repeatedly told him no, at which point David pushed his way past Stacy into the residence. As he entered, she ran out of the apartment. That's when he grabbed the cell phone from her, which this is arguably a life felony. I don't know why it wasn't arrested as such, but it wasn't. He grabbed the cell phone and then ran to the back door and says, "Bitch, let me in if you want this phone." So it's not just a flagrant violation of court order. It's not just a complete disregard for what the court has ordered, but part of the reason for that is the victim's safety and to protect the citizens of Orange County. This is a pretty flagrant violation of that order and evidence that your client is demonstrating he willfully has no intention of following court orders. So what in this case can this court order that's going to convince your client he should obey this court order when he just violated the last court order? What's different today? What can I order today?
Your Honor, again, I believe if you set a monetary bond as well as place him on pretrial release to be monitored, that would suffice in this case. Again, I see the arrest for the battery and the violation. I don't see a conviction, Your Honor. And he does not have, again, a history of violating domestic violence injunctions. This is his first one that happened in May. I don't see him showing a pattern of just disregarding the court's order. My client is disputing those allegations that are in the arrest affidavit, Your Honor, and because he doesn't have that history of violating the domestic violence injunction, I'm asking for a monetary bond and pretrial release in this case.
I'm not inclined to do that. What says the state?
Your Honor, the state will leave it within your discretion. I do see that prior BAT DV case. It was dismissed due to the victim being unwilling to prosecute. That was date of incident on that case was back in April of 2021. She subsequently got the DV injunction, citing a lot of the incidences that happened in that case as well as other incidences prior to that incident. So state will leave it within your discretion, Your Honor.
At this time, I'm going to stay my order. We can bring him back at the end and we can see if I'll change my mind, but not now. Good luck, sir.
Thank you.
Sorry. No bond right now. We can't get out. Please tell me your name.
Osiris Malcolm.
Good morning, sir. You're here in 21 CF 15006, charged with aggravated battery on a pregnant person, domestic violence. There is probable cause. I'll appoint an attorney to represent you.
Would I be able to talk to him now?
Your attorney?
Yes.
Yes. Ms. George, do you want to
Yes.
take a moment to discuss with your client? Bye. Have a nice day.
Thank you, Your Honor.
All right, Mr. Malcolm, your bond on this charge is $5,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yes.
You can have no unsupervised contact with any minor child under the age of 18. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Please tell me your name.
Tyler Wilson.
Morning. Mr. Wilson, you're here in 21 CF 15008, charged with battery on a person 65 years of age or older. At this time, I'll appoint an attorney to represent you. I know what you're going to say, but I read it. I think there is probable cause.
Your Honor.
Or let me say, I think I know what you're going to say, but please go ahead.
Yes, Your Honor. I agree. It's just that my only issue is that we're getting these arrest affidavits that are like this. And for example, my client is currently on probation. We're going to violate his probation for an incident that is 3 sentences long. There's no facts in here as far as who called the police, how the officer ended up at the residence. Did he shove him against his will? What did the victim say? We don't know. We just have a blanket statement from the officer, essentially throwing in a couple facts that'll go with the statute, which is the issue, Your Honor. However, reading it, it does meet the elements, but of the battery. I just think it's bad practice, Your Honor, because we don't have any other facts or information in this arrest affidavit as to what really occurred.
Yeah, I read it skeptically more than once because I was anticipating this argument.
Yeah, sure.
However, unlike most of our others that are 3 sentences long, this one actually says
Yes.
by actually and intentionally attempting to throw a phone at the defendant's grandfather before shoving the grandfather, who's over the age of 65 years, to the ground against the will of the victim. So it actually has those facts. Usually it doesn't have that.
Yes, Your Honor.
What says the state?
Your Honor, for PC purposes, it comports to the elements that we need for a bat over 65. It alleges that the victim is over 65 and there was an intentional touching against their will. I understand defense counsel's argument that it's bad practice. However, discovery will be exchanged later, and this issue will likely be alleviated at that point. I don't believe it's a consideration for PC purposes here today.
I don't think it is either. I think there's enough for probable cause, but I agree it's a threadbare affidavit.
Yes.
Mr. Wilson, there is probable cause here for this charge. Your bond is $5,000. With special conditions, you can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand that? You understand what no contact means? All right. You're also on probation out of Seminole County. It looks like 19-00064. At this time, there's a violation of probation based on this new law violation. So you'll have no bond on that. I'll appoint an attorney to represent you in that case as well, and we'll notify Seminole County that you're here so they can transport you, and we'll have the attorneys work together in Seminole and Orange. Good luck. No. It was. I read it several times.
Yes, Your Honor.
Please tell me your name.
Sean Bird.
Good morning, sir. You're here in 21 MM 8230, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am. I read the paperwork given to me.
Thank you. You can't possess a weapon of any kind, firearm, or ammunition. You can't possess or consume any alcoholic beverages. You'll be subject to random alcohol screens. You can't have contact with any witness in this case. You must maintain a separate residence.
Okay.
That was scary.
Hold on.
Yes, ma'am. I did.
Pretty sure the record, hold on. I don't think the record's working yet. It's gonna reboot, so we gotta stop. I'm so sorry. This has literally never happened before. Yeah, it says the system is starting up, so I'm just gonna take a break. I'm sorry.
Yes, ma'am.
Wow. Have you ever seen that?
Oh, it's not.
It's probably not.
I know he has.
Yeah. Yes. The way you got inputted, most likely. That's just probably a PC statement of the end of another affidavit.
It looks like the touch panel has lost it. All right. We're gonna take a recess. If you wanted to put him back there so he can have a seat, because I don't know how long this is gonna take, but I don't think it's gonna be quick. Hey, it looks like the record is back. So it's 9:45 on November 22nd, 2021. We are back on the record. We could bring Mr. Bird back out. All right, Mr. Bird, sorry about that. We're still here in 21 MM 8230. It looks like the record is back up and running, and you said you had a question.
I was going to make a statement saying that once
wait.
we leave,
Oh,
I would be returning to my mother's residence in Jacksonville, so I would be staying away from the person in contact.
Okay, that's perfect. Just remember that if you're in Jacksonville and you have a court date, you have to either come for your court date or If it's virtual, you'll have to appear virtually. That's up to the judge whose docket this case gets assigned to. So you want to make sure you don't miss a court date.
I also do have a private attorney on.
Oh, you do?
retainer. I just chose not to use it in this instance, so if I need to, for him to be in court, I will have him present.
So,
If I'm out of town and I need someone present in court, he will be there.
all right, so then do you want me not to appoint a public defender?
Ma'am, appoint the public defender, please.
All right, so that's not really how this works. Let me explain it.
I'm not gonna use my private attorney because I don't think I need to pay him the amount for this small of a ordeal.
So that's not really how this works. If you can afford to hire an attorney, you're not entitled to the services of the public defender. The only reason I appointed them this morning is because of the pandemic. The Supreme Court of Florida issued an administrative order saying that everyone should be assigned the public defender so that no one was sitting in jail without the ability to talk to an attorney.
Yes, but I
But-
cannot financially afford a private attorney. I have one that is a friend, but I cannot financially afford him. So I want the public defender, please.
All right, I'm going to appoint your office for now, Ms. George, but maybe make a note.
Yeah, sure.
All right. What did I order in this case? Sorry, because we took that break, I need to make sure I didn't forget anything. No, okay. All right, good luck, sir. Please tell me your name.
Ernesha Conyers.
You're here in, good morning, ma'am. You're here in 21 MM 8214, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You can't possess or consume alcoholic beverages, and you'll be subject to random alcohol screens. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Are there any other conditions the state would request?
No, ma'am.
No, the state.
Your Honor, I believe this occurred at a Days Inn hotel. I don't know if you're going to allow a return there if she otherwise needs it, and there also was an independent witness.
No contact with the witness. And ma'am, do you have belongings at the Days Inn?
No, ma'am.
Okay, so she doesn't need to go back there.
Understood.
All right, good luck.
Thank you.
Thank you, Ms. May. Because I don't know where they live. Good morning. Please tell me your name.
Nathaniel Davis III.
21 MM 8232. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case. Your bond is $500 with special conditions. You can have no contact with a victim or any witness in the case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition.
No, ma'am.
Okay, thank you. You must maintain a separate residence from the victim. I'll allow a one-time return with law enforcement to gather your belongings. You must comply with any plan set in place by DCF, and you can have no unsupervised contact with any minor child under the age of 18. Do you have belongings at this hotel?
It's not a hotel, ma'am.
Hampton Inn? This didn't happen at the Hampton Inn?
No, ma'am. Well, no, the event happened at the Hampton Inn, but we don't live there.
Okay, all right, so you don't need to go back there.
No, ma'am.
Okay, all right, good luck, sir.
All right, thank you, ma'am.
I was like, I know that's what it says. Good morning, please tell me your name.
Anna Douglas.
21 MM 8220. Ma'am, you're here charged with battery, domestic violence. There is probable cause, and I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm, or ammunition. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. You must maintain a separate residence from the victim, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck, ma'am.
Your Honor, there was also a witness as
Hold
well
on.
as a child and DCF contacted.
Hold on, you gotta bring her back. Sorry, I didn't write that. Ma'am, you'll have to comply with any plan set in place by DCF, and you can have no unsupervised contact with any minor child under the age of 18, and you can have no contact with any witness in this case either. Do you understand?
So I can't have my daughter no more?
You can't have unsupervised contact with minor children, and you'll have to comply with any plan set in place by DCF. DCF was contacted, so I don't know what their plan will be, but you're gonna have to comply with that. Thank you. Please tell me your name.
My name is Enrique Gomez.
Good morning. You're here in 21 MM 8229, charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case. Good morning, ma'am. Did you wish to testify? No, you don't want to testify?
Not right now, no.
All right, thank you. All right, sir. In this case, your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand? You also can have no contact with any witness in the case. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Good luck, ma'am.
Can I say something?
Yes, ma'am. One wait.
I think you're gonna have to bring him back, because.
Yeah, he's gonna have. All right, we're back on the record in 21 MM 8222. Ma'am, you said that you didn't want to testify, but now you do want to testify?
Yeah.
Okay, raise your right hand, please.
Do you swear or affirm the testimony you're about to give, share with the truth, the whole truth, and nothing but the truth?
Just the truth, yes. I swear.
Okay,
Okay.
thank you.
Please state your name for the record and spell your last name.
Alana Valentina Almestica.
Your Honor, also for the record, I believe it's 8229.
Wait. Yes.
Mr. Gomez.
Hold on 1 second.
That's right. It is 8229.
I just don't
All
want.
right, yes, ma'am. What is it you wanted to tell the court?
I basically wanted to see about the possibility of at least getting mental or psychiatric check, because that was something we were already in the works of in the first place with his job, getting insurance through them to get him help mentally in the first place. So I don't want to lose that contact. I just really want to make sure he at least gets a psychiatric evaluation at least. So that's what I want to say.
Thank you. I appreciate that. Unfortunately, I don't have jurisdiction to order anything like that. So I'll ask his attorney if she can make a note for her colleagues. But at this time, I don't have the ability to order any kind of psychiatric, I can't order even evaluation at this point. So he has an attorney. We'll see if they can make a motion for that in his case in front of the trial judge.
Okay, and the no contact you said will still stand regardless
Yes,
until his court date?
right, until another judge changes it.
Okay,
It'll be in front of Judge Shoemaker, and he can change my order at any time. But until he does, all of my orders stay in place.
okay.
All right, good luck. Thank you, ma'am. Good luck. Thank you, Ms. May. I had already moved on to the next sheet, and then I saw on the computer it was a different case.
It's fine. Since the record keeps going out, I just didn't want it to be more
Right.
confusing.
No, we don't need any more confusion. Good morning. Please tell me your name.
Adrian Hernandez.
You're here in 21 MM 8222, charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm or ammunition. You can't possess or consume any alcoholic beverages. You'll be subject to random alcohol screens. You must maintain a separate residence from the victim, and I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes.
Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Good morning. Please tell me your name.
Keith Mccauley.
You're here in 21 MM 8224, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. You can't possess a weapon of any kind, firearm, or ammunition. Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Good morning, sir. Please tell me your name. All right, Mr. Mcnair, you're here in 21 MM 8235, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Just a moment. Your bond is $500 with special conditions. You can have no contact with the victim or the witness in this case. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence from the victim, and I'll allow a one-time return with law enforcement to gather your belongings.
Your Honor, I also believe DCF was contacted.
You must comply with any plan set in place by DCF. You can have only supervised contact with any minor child under the age of 18. Good luck, sir. Good morning, ma'am. Please tell me your name.
Audi Morales.
You're here in 21 MM 8221, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition.
Okay.
Do you have belongings at the Hilton Hotel on East Buena Vista Drive?
No.
I'll order you're not allowed to return there. Are there any other conditions the state would request?
Your Honor, did you order a separate residences and a one-time return?
I'll order you must maintain a separate residence and allow a one-time return with law enforcement to gather your belongings. All right, good luck.
Thank you.
Good morning, sir. Please tell me your name.
My name is Pagan Ian. Oh, huh? My name is Ian Sean Pagan Puno.
You're here in 21 MM 8225, charged with battery, domestic violence. There is probable cause, and I'll appoint an attorney to represent you. Good morning, ma'am. Do you wish to testify?
I'm his mother.
Do you wish to testify?
Yes, please.
All right, please raise your right hand.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record and spell your last name.
Rosa Soto Pagan.
Sir, while she's testifying, I need you to look at me or this wall.
I am. I'm looking at you.
Thank you. Go ahead, Miss May.
Good morning, ma'am. Can you please state your relationship to Mr. Ian Pagan?
He's my youngest son.
Are you afraid of him?
No, I'm not.
Has anything like this ever happened before?
No, and I would like to say something because I'm worried about bond. I just literally don't have a job right now. I'm supposed to, but hopefully be starting tomorrow. He's the only person with the income in the house right now. Also, he's supposed to be in school. He's supposed to graduate in December. He's never been in trouble before. It was both of us. We were both arguing with a lot of the stress that's been going on in the house. I really wanted him Baker acted because he's been Baker acted before, like years ago. But like, he's a good kid. He doesn't get in trouble. Like, I know where he's at 24/7. Like, this has just gone way too far. Like, I just wanted him to stop and, take a breath, calm down. He has medicine waiting for him at Walmart that he is supposed to be on, but he does not get in trouble. He does not. I don't want to see him here. Like, I feel like he needs help not to be here.
Unfortunately, ma'am, in the state of Florida, if you touch someone intentionally against their will, it's a crime.
I don't.
And so that's why law enforcement arrested him. I
Yeah.
read the affidavit. There was probable cause for the arrest. I understand what you're saying, but law enforcement, their primary job is protecting the citizens, right? So that's why he was arrested and that's why he's
And
here.
it was both of us though. Like I also trying to get him off me, shoved him and also provoked and said some things too. It wasn't just him. I don't want him to fall for blame for everything when it was really both of us. I tried to wait 4 hours to see if we could both escalate, de-escalate the situation. But I guess he was just so angry and wanted to be heard with everything going on at the house. And I wasn't trying to hear him at the time, like I just wanted to be left alone. I have a lot going on, but I just want to get him out of here. So he does have counseling in place. He also has the medicines and he does abide by me. Like he doesn't, this is a first. Like I don't even know where it came from.
All right, Ms. May, do you have any other questions?
One briefly, Your Honor. Do you want to have contact with him?
Yes, and I want him to come back home. He don't have nobody else but me. He don't have, not even my phone number. I haven't been able to speak to him. He don't know my number, nothing, nothing. He doesn't have nobody but me.
All right, Ms. George, any questions from the defense?
No, Your Honor.
All right, based on the victim's testimony and the facts contained within the affidavit at this time, do you want to ask for something for bond?
Your Honor, I was going to ask for a pretrial release in this case. Given the victim's testimony and a no hostile contact order, given his criminal history and the victim's testimony, here today.
All right, I'm going to do that. At this time, sir, I'm going to place you on a program called pretrial release. But because it's domestic in nature as charged, I believe the statute requires that I also require you to post a monetary bond. However, I'll reduce that amount significantly to $100. And then based on your mother's testimony here today, I'm going to order that you can have no hostile contact with your mother. So peaceful contact only. Do you understand what that means?
Yes, I understand.
No yelling, no shoving, no hitting.
Oh, I love my mom.
I believe you. Listen, Mr. Pecan, calm down.
He's
it's
never
okay.
been in trouble. He's never been in jail, so he's scared out of his mind, I'm sure.
It's okay.
Ian, relax.
Just calm down and breathe. Listen, you're going to be released. I just want to make sure that you understand what I'm ordering you to do because I don't want you to be brought back here for violating it.
I donate plasma so I can easily get the money within the next 2 days or so. I get special bonuses and everything.
All right, I just want to make sure you understand. You still can't possess a weapon of any kind, firearm or ammunition.
I don't plan on to. I don't.
Okay, that's good. But listen, your mom just told me that you guys are under a lot of stress at the house and that's causing you guys to maybe fight a little bit. I want you to understand that if you guys get into another fight, if I were you, I'd walk out the back door because if you get rearrested, you can be held with no bond. Do you understand that?
Yes, I know that.
Okay, I'm not saying you will be. I'm saying
no,
you
no, I
could
get it.
be. Okay?
I understand.
All right. Good luck, sir. Good luck, ma'am. Thank you for coming.
Thank you so much. Thank you.
Good morning, ma'am. Please tell me your name.
Kimberly Recton.
You're here in 21 MM 566, charged with battery. There is probable cause. I'll appoint an attorney to represent you. Good morning, sir. Do you wish to testify?
Yes, I would.
Please raise your right hand.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record and spell your last name.
Gregory Recton, it's spelled Rechdin.
Ms. May, do you have some questions?
Yes, Your Honor. Good morning, Mr. Recton. Can you please state your relationship to Kimberly Recton?
She's my wife.
Are you afraid of her?
No, not at all.
Has anything like this situation ever happened before?
No, not really, not like this. I mean, typical arguments, 20 years of marriage, and just a little bit too much alcohol on Sunday. And that's basically what started any of it, was just the fact that I said that was enough. And, you know, I think things just got really out of hand. And I'd like to see her. I'm not afraid of her. As a matter of fact, I didn't even call the cops. She did. And they came and dealt with her because she just was out of hand. That's all. But I really don't want to see anything happen to her. I love her very much. And I'd like to have her at home. But also, if she can go and stay with her mom. She's done it before when we've had arguments. We just need some time apart. But I don't really think that she needs to have a book thrown at her or anything like that for this. It's just simple as that.
Thank you. Any other questions, Ms. May?
He basically covered it, but I just want to make sure I get the answer on record. So you do want to have contact with her?
Yes, I definitely do.
All right, thank you. That's all I have, Your Honor.
Anything, Ms. George, from the defense?
No, Your Honor. I would just ask for a no hostile contact order given the victim's testimony here today. And she does qualify for pretrial release, Your Honor, given her history.
All right, thank you, sir. Ma'am, at this time, I'm going to place you on pretrial release, but I will require that you post a monetary bond. I'll reduce that amount significantly to $100. With special conditions, you can have only peaceful, he can stay. You want to stay here until I'm done? You can stay. You can have only peaceful contact with your husband. Do you understand what that means?
Yes.
No hostile contact, no yelling, no pushing, no shoving, no hostile contact. You can't possess a weapon of any kind, firearm or ammunition. You can't possess or consume alcoholic beverages, and you'll be subject to random alcohol screens while on pretrial release. Do you understand? Any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am. Good luck, sir. Thank you for coming.
Thank you.
Good morning, sir. Please tell me your name. You're here in 21 MM 8233, charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. I'm concerned about his out-of-state ties, lack of in-state ties, and his extensive violent history out of state. Ms. George.
Yes, Your Honor. He's from out of state. I just show 0 failures to appear. That's out of state, but he's not from here, Your Honor, so.
Right.
I would just ask for a monetary bond, Your Honor.
I'm sorry, go ahead.
I understand the tie situation, Your Honor. I have no.
Does the state wish to be heard?
No, Your Honor. Your Honor already eliminated the concerns that the state has regarding the out-of-state history and the lack of community ties.
All right, sir, your bond is $1,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. Do you have belongings at the courtyard by Marriott?
I do. It's in. They're being held by the hotel, by the lobby, in the lobby. Yes, ma'am.
Okay, I'll allow you a one-time return there to gather your belongings. You'll have to maintain a separate residence from the victim, and I'll allow a one-time return to that residence as well, should you need it. Any other conditions the state would request?
The defendant, I believe, or the person that I got into it with, he has my wallet, credit cards. So how I guess I would need to get in contact with him to pay my.
You cannot. You can have no contact with him. So what you should do is ask your attorney if they can figure out how to arrange gathering those belongings from him, because you cannot have any contact with him.
Okay, and so I can just talk to a third party, like maybe my mother or something like that, to do that. Or...
You can do that, but you can't send a message to him. So no contact means you can't use a third party to send a message to the victim. So what that would mean is talk to your attorney about contacting your mother to see if your mother can arrange or his mother can arrange the pickup, but it can't involve you.
Sure.
All right?
No,
Good luck. Thank you. Please tell me your name.
Sanchezly.
Mr. Lee, it looks like you have a warrant out of Duval County in 2021 AF 12056 on a charge of battery by strangulation, domestic or dating violence. The bond is $2,003. We'll notify them that you're here so they can transport you, and I'll appoint an attorney to represent you in the meantime. Good luck.
Your Honor,
Yes.
for that bond, I think it was 25,000.
What did I say?
To 2,000.
$25,003.
You said 2,003.
I said two?
Yes, Your
I'm
Honor.
sorry, bring him back. I read 25.
I thought it was low, but
Very low. No, I read 25, but I just apparently misspoke. I'm sorry, Mr. Sanchez. I read that your bond was $25,000, but apparently I said it was $2,000. Your bond is $25,000. Do you understand that? All right, sorry about that. That was my mistake.
So if I pay the bond, will I be able to get released?
You can.
All right.
Thank you. Sir, please tell me your name. Sir, you can ask anything you want. Everything you say here is being recorded and can be used against you later. Let me tell you why you're here first, okay? That might answer your question, I don't know. You have a warrant out of Polk County, it looks like, for violating probation on a charge of grand theft of a firearm. That's in 19 CF 1665. So at this time, you have no bond. Did that answer your question?
No, ma'am. I did time in Seminole County. I did 79 days, and they told me that once I do that, I'll be off probation. Then a cop told me that my probation ended November 18th, and today is November 22nd. But I was finished with probation in September, and I didn't know anything else about it.
In Polk County?
I transferred from Polk County to Seminole County.
Yes.
Your Honor, are you able to change this warrant? No bond?
I am not, because it's an out-of-county warrant. It's in Polk County, sir. And literally all I have is that information for the warrant. So you may be correct, but there's nothing I can do to change it. What I would tell you is, even if your probation has ended, if a judge issued a warrant for you for violating your probation before the probation ended, that warrant still has to be addressed. So you'll want to go back to Polk County and address that with that judge. Honestly, I don't know what you did either. I can't tell you because I don't have access to it. It's in Polk County. But so I appointed an attorney to represent you. Ms. George, can you make some notes for your colleagues? Because if you guys can talk to Polk County and figure out if there's something we can do it here, but right now there's not. Good luck, sir. Call your attorney right away. Please tell me your name.
Manuel Will.
Sir, you're here in 20 CF 15320. A capias was issued for your arrest for failing to appear for a status hearing on charges of possession of a controlled substance with intent to sell or deliver and possession of drug paraphernalia. At this time, there's no bond authorized on that capias. I'll appoint an attorney to represent you. Good luck, sir.
Your Honor, there's a second one as well.
I have that he's not here on that case. Hold on.
On the VOP?
So it says on the phase sheet that 15320 is a violation of probation, but that's actually the capias for failing to appear, but it's drug court.
Okay, understood.
So I don't have another one. Is there another one?
Yeah, there should be 2 warrants with the same case number.
Okay, hold on a minute. I have one. I just have the one. Was there a warrant
Yeah, a warrant.
actually served, not the FTA?
Yes, it was the FTA warrant,
No, it's a capias.
and then there was the VOP warrant.
I don't have a VOP warrant. Hold on. Maybe I can open this. Wait. Wait, I do. It is there. Hold on. All right, so sir, in addition to the capias, there is actually a warrant. Sorry, I didn't see that I could open that. There is actually a warrant for violating that same probation in the same case number. The allegation is you changed your residence without procuring the consent of your probation officer, and there's no bond authorized on that warrant either. So I'll appoint an attorney to represent you, and you'll have to see Judge Lattimore. Good luck, sir. Sorry, that was really confusing.
We skipped Miles Lomax.
Yeah,
He's in the hospital now.
and Littleton.
Littleton already went out.
Oh, that was that. Okay, so we skipped.
Lomax is in the hospital now.
All right. So we have to do that because we still have to address it on the record. It's 19 CF 1307. Ms. George, I'll appoint your office. It's a violation of probation out of county.
I'll waive the appearance, Your Honor.
All right, there's no bond. Okay, so that's all we have for the morning. Do you guys want to take a break now? Oh, we have these, yeah.
And did you want to readdress Jones?
No. Good morning, sir. Please tell me your name. What's your name, sir?
Charles Davis, Jr.
Mr. Davis, you're here in 21 CF 15005, charged with possession of a controlled substance, resisting an officer without violence, carrying a concealed firearm, open container, possession of alprazolam, possession of a firearm in the commission of a felony, and possession of cannabis under 20 grams. At this time, I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard on any of these charges?
No, Your Honor.
I reviewed the affidavit. I found probable cause, but wanted to make sure if you had seen something I didn't, that I gave you the opportunity. Sir, there is probable cause for these charges. I'm going to stay your bonds as listed in the affidavit.
Your Honor.
Yes.
Sorry. For the possession of a controlled substance, the I would argue no PC. I only see the alprazolam that the officer found. I did not see any other substance.
Your Honor, I believe law enforcement found multiple pieces of yellow unknown rectangular shaped substance, which was presumptive positive for alprazolam.
Yes.
And then found other multiple pieces of yellow rectangular pills that also was alprazolam. I believe the only two narcotics that were located on the defendant were the alprazolam and the cannabis. Unless I'm potentially reading over it. If that is true, then state would ask for an ROR as to either the controlled substance or alprazolam, as I believe it may be a duplicate.
So it says in the affidavit, I don't know, a little more than halfway down, multiple pieces of yellow in color unknown, oval-shaped pill-like substance resulting in negative results. So when I read it, and then later it talks about the one that tested presumptively positive for alprazolam. So when I read it, that's why I found probable cause for both counts, is that it appeared to me that the way they're writing it, it's as though he had pills that did not test presumptively positive for alprazolam, and then some that did. But if the state reads that differently.
Okay, I see what you're talking about. The yellow rectangular ones, which were alprazolam, and then the yellow
Oval-shaped.
which were negative.
So it says a field test was conducted of those with negative results. So it did not test positive as though it was alprazolam. But then the next section of pills that they found did test positive for alprazolam, which is why I found probable cause for that count one.
I think, but it says when it didn't test positive, resulting in negative results. However, through investigative means, the officer did the drug.com/pill finder, and then the multiple pieces of yellow in color. That pill was tested and it was alprazolam, but this pill came back negative. So I would just argue that possession of a controlled substance, there is no controlled substance for the oval shaped as it tested negative.
Right, so the one that tested positive and that came back in the pill finder was the alprazolam, and that's the rectangular shape. The oval shape
did not.
Did not.
Correct.
So you're saying there's not probable cause that it's anything?
Yes, Your Honor.
What says the state?
Your Honor, state has no objection to that. Since it came back negative, we currently don't know what it is. Arguably at this point, it could be a Tylenol, which he is allowed to have. Until FDLE comes back, we do not know what that pill is, as the officer did not find it on drugs.com nor through a presumptive field test. So state we just asked for an ROR as to count one.
All right, I will do that. So, sir, you'll not be required to post a bond on count one. I'll release you on your own recognizance. Count two will be $500. Count three, $2,500. Count four, $250. Count five, $1,000. Count six, $5,000. And count seven, $250. With special conditions, you can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. You can't possess a weapon of any kind, firearm or ammunition. Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Good morning, sir. Please tell me your name.
Torres.
Just a moment. No, I found PC, but I still ROR'd him at their agreement. Yeah, no. All right, Mr. Torres, you're here in 21 CF 14998, charged with possession of cocaine, and 20 MM 6804, because a capias was issued for your arrest for failing to appear for a hearing on a charge of trespass other than a structure or conveyance. At this time, I'll appoint an attorney to represent you in both of these cases. Ms. George, did you wish to be heard?
No, Your Honor. Can I just have a moment?
Yes.
Thank you, Your Honor.
All right, sir. I reviewed the affidavit. There is probable cause. Your bond on the possession of cocaine is $1,000 with special conditions. You can have no contact with any known drug dealers, and you can't possess or consume any controlled substance without a valid prescription. Your bond on the trespass, on that KPS, it's $500. I'm not going to change that. Good luck, sir. Sir, you can say anything you want, but everything, hold on, let me explain to you. Sir, let me explain something to you first. Everything you say today is being recorded and can be used against you later. Do you understand that? All right, go ahead and raise your right hand. Sir, raise your right hand. Thank you. Hold on.
Do you solemnly swear and affirm the testimony you're about to give shall be the truth, the whole truth, so help you God?
Yeah.
All right, go ahead, sir.
I have no job, so how does the way I could bond out? Pay a bond out, I don't have no job. I don't get all hard. I told him I don't have no job at all for nothing. I have no way to work. I have no job. I'm trying to fix my life. I keep putting me back in jail. I was out of jail for 7 months, doing good. I have a job. There's no way I could bond out.
Sir.
After Thanksgiving, I lost my job today. I just recently found a job. I was able to go to my job today. It's continuously, bro. I've been paying my fines. I've been doing everything I had to do to stay out of jail. I don't have no job. I can't pay nobody. I don't have no family out here. I'm by myself.
I understand, sir. At this time, I'm not inclined to reduce your bond. I'm looking at your criminal history. And since he stormed out, I'll not continue. Well, let me just say, he has 3 prior failures to appear, his last one being just last year. He's got several prior convictions, and he's before this court today for failing to appear for court. One of the purposes of bond is to secure the presence of the defendant for later court dates. So at this time, I'm not reducing that bond.
John Sanders is medical.
21 MM 720. It's an arraignment, Ms. George. Your office is already representing him.
I'll waive and enter a plea of not guilty, Your Honor.
Division 80, pretrial conference, December 20th at 9 o'clock, courtroom 9C.
Good morning, sir. Please tell me your name.
William Luna.
Mr. Luna, you're here in 21 MM 8219, charged with trespass on property after warning. Sir, I see that you're resting on your arm there on the podium. Are you feeling okay? Why not? All right. Is that affecting your ability to understand what I'm telling you here today? All right, sir. I'm going to appoint an attorney to represent you in this case. There is probable cause here.
Your Honor, state did convey an offer of an adjudication, credit time served, no return to Advent Health, located at 601 East Rollins Street, absent a medical emergency.
Your Honor, he's stating he's fine. Not sure.
The court is concerned about his well-being at this point. It doesn't look like he's able to participate in the proceedings. So I'm not inclined to accept a plea on this right now. Sir, you have a bond. Your bond is $500. You can't return to Advent Health at 601 East Rollins Street unless you have a medical appointment or there's an emergency. Do you understand? Do you understand that? All right, call your attorney right away, sir. Ms. George. If he's feeling better by the end of court today or by tomorrow, we could always bring him back if he wants to accept that plea, but I'm really concerned about his behavior.
Your Honor, since he is homeless, I don't believe he has anywhere. Can we try to reset it for tomorrow?
Yes.
Just to see if he's feeling better?
Right. I'm fine with that, and I'll make sure Judge Bain knows that. He'll be fine with it too. I'm just concerned about that behavior. I don't think he's in a good frame of mind for that. Okay. So, did you get that? We're going to reset him for tomorrow? Okay. Yeah, leave it all. If somehow he's able to bond out, he's welcome to, but if not, we'll bring him back tomorrow.
Thank you.
All right. Good morning, sir. Please tell me your name.
Ryan Rondo.
Mr. Rondo, you're here in 21 MM 8223, charged with retail petty theft. At this time, I'm going to appoint an attorney to represent you in this case.
Your Honor, I would ask for pre-trial release in this case. He doesn't have any criminal history.
I see that. There is probable cause. Does the state have any objection?
No, Your Honor, state has no objection to pretrial release. We just ask for no return to the
Walmart?
scene. Yes.
All right, sir. At this time, I'm going to place you on pretrial release. With special conditions, you can't return to Walmart located at 11930 Narcoossee Road for any reason. Do you understand that? You can't have contact with any witness in this case. Sir, call your attorney right away, okay? Good luck. Yeah, that's it. Good morning, sir. Please tell me your name.
Mr. Joseph Dyer.
Mr. Dyer, you're here in 21 MM 220 because a capias was issued for your arrest for failing to appear for a plea hearing on a charge of trespass on property other than a structure or conveyance. The bond authorized is $2,000, and you have an attorney.
Your Honor, state did convey an offer on this of an adjudication, credit time served, no return to the Citgo gas station located at 660 North Orange, and a cost of investigation to Winter Garden PD of $135.19.
All right, Ms. George.
Yes, Your Honor, I did have a chance to speak to Mr. Dyer. We went over all the rights he would be given up. He understands those rights and would like to accept the state's offer here today.
Please raise your right hand, sir.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
All right, Mr. Dyer, put your hand down. You can put your hand down now. You had the opportunity to speak with your attorney before court about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights? I couldn't hear you. I'm sorry. Thank you. Sir, do you have any questions for me about the rights you'll be giving up?
No, ma'am.
Did you have an opportunity to read that form in front of you? It's the plea agreement, and it further outlines those rights for you.
Yep.
You understand if you're not a U.S. citizen, you could be deported?
Yeah.
You understand if you're on probation anywhere, this plea could violate that probation?
Yeah.
And you understand the terms of the offer that the state conveyed, right? At this time, sir, how do you wish to plead to the charge of trespass on property other than a structure or conveyance?
No contest.
I'll accept your plea, sir. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for 20 days that you've been in custody. Sir, I have to order that you pay court costs and the cost of investigation. You're not allowed to return to...
The Citgo gas station located at 660 North Orange Ave.
Do you know where that is?
Yes, ma'am.
Okay, you can't go back there, sir. Good luck. You have 30 days to appeal in writing. Yes, sir. Have a nice day. Please tell me your name.
Angela Martinez.
21 MM 5569. You're here because a capias was issued for your arrest for failing to appear for arraignment on a charge of petty theft.
Your Honor, state also did convey an offer in this case of a withhold, credit time served, and no return to the Walmart at 8101 South John Young Parkway. However, I did tell defense that Ms. Martinez would likely qualify for PTD downtown.
Yes.
All right, Your Honor. I did speak to Ms. Martinez. We went over all the rights she would be given up, and she would like to accept the state's offer here today.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
All right, and Ms. George, did you also explain to her that this charge is potentially enhanceable?
Yes, Your Honor, I did.
All right. Ms. Martinez, you had an opportunity to discuss with your attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights? Do you have any questions for me about them? Okay, did you have a chance to read that form in front of you? It further explains those rights to you. I'm going to give you a moment. I want you to read that. All right, do you have any questions for me about that? And your attorney explained to you that petty theft is what we call enhanceable, which means after so many convictions, the state can file it as a felony. Do you understand that? All right, at this time, ma'am, how do you wish to plead to the charge of petty theft?
No contest?
I'll accept your plea. I find it's freely and voluntarily made. Ms. May?
Yes, Judge.
Can you remind me what were the terms of the agreement?
Withhold credit time served and no return to the Walmart at 8101 South John Young Parkway.
Why would the court withhold adjudication?
I believe her only history that she has, Your Honor, are driving offenses, given that this is an enhanceable offense, and she would otherwise qualify for PTD. State law to withhold at this time was reasonable.
All right, I'll withhold adjudication, give you credit for the time you've been in custody.
2 days.
2 days. Order that you're not allowed to return to the address the state put on the record. You have to pay court costs. I'll give you a year to pay those. Is there anything else, Ms. May?
No, Your Honor.
All right. Good luck, ma'am. You have 30 days to appeal in writing. Yes, ma'am. Good morning, sir. Please tell me your name.
Chang.
Sir, you're here in 21 MO 1358, charged with disorderly conduct. There is probable cause.
Your Honor, the state offered on behalf of the city a withhold credit time served to resolve Mr. Chang's case. We did go over all the rights we'd be giving up. He understands those rights and would like to accept the state's offer.
I show that he's out on bond in 2 cases.
Yes, Your Honor. However, being that they're, I think it was a 33-day motion. I'm not sure any information was filed in that case, Your Honor. And the fact that the charge that he picked up is a nonviolent offense, not drug-related, Your Honor. I would ask that you take all of that into consideration.
Did you have an opportunity to explain to him the court may still revoke those bonds?
No, Your Honor.
I'll give you a moment right now.
Your Honor, he understands he still would like to take this state's offer.
All right, Mr. Chen, please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
And I'm just looking at his history. Did you all look at that? It says that he has 156 unknown. And out-of-state arrest history includes a deportable alien arrest.
Yes, Your Honor. I don't know if he's since obtained citizenship. The front page does say that he's a U.S. citizen now.
Yeah, I asked. He said he is a U.S. citizen, Your Honor.
And 156? That's an exorbitant amount of anything.
I can check CCIS, Your Honor. However, I don't know if it's all Florida or other.
Hold on.
Your Honor, it does appear per CCIS that it does seem that he has a significant amount of traffic-related, county ordinance-related, municipal ordinance-related offenses, all with the same underlying soliciting funds. That may be where a lot of those unknowns potentially come from.
All right, Mr. Chen, you had the opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest today. Do you understand those rights? Do you have any questions for me about those rights? You understand if you're not a U.S. citizen, you could be deported? You understand if you're on probation anywhere, this plea could violate that probation. And you also understand that you are currently out on bond. You were released on your own recognizance for 2 felony charges. At this time, this court has not decided if I'm going to revoke those bonds. Do you understand that? All right, sir. At this time, how do you wish to plead to disorderly conduct?
No contact.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay that.
Your Honor, in regards to his out on bonds, in reference to the 7646, that ROR was subject to a 33-day motion. We had since filed on it, but he is currently in PTD for that offense. And in regards to 12399, state has not filed on that case to date.
All right, sir. At this time, I'll take no action on those cases. Good luck. You have 30 days to appeal in writing. Good morning, sir. Please tell me your name.
Nigel.
Nigel what?
Clark.
Good morning, Mr. Clark. You're here charged with disorderly conduct in 21 MO 1359.
Your Honor, and, oh, did you find?
There is probable cause.
The state, on the city's behalf, is offering a withhold of adjudication, credit time served. I did speak to Mr. Clark. We went over all the rights he would be giving up. He understands those rights and would like to accept the state's offer here today.
I don't know if I'm inclined to do that. It looks like the allegations are a fight. He has, well, I guess they're just arrests. Does he have any convictions for violence?
Not that I see, Your Honor. At least not within Florida. I have no access to Georgia. I believe there is an outstanding warrant, however.
What's the warrant in Georgia?
I believe it said burglary. From 2017.
What was the state's offer?
You're on the city's behalf, state can withhold credit time served.
Is this Georgia warrant, has it been served?
No.
Is it
I
not?
don't believe
They're not extraditing?
No, they're not extraditing.
I don't know that I'm inclined to do that, Ms. George. He has a violent history, and the allegation in this is a fight. So it's violence. This isn't panhandling.
Are you, Your Honor, are you saying you want to do an adjudication so I can talk to him? I don't know what you're willing to accept.
Yes, and I might also extend the jail time.
Do you have an idea of how many days so I can?
No. If he enters a plea, I want to ask him about it.
Oh, the fight.
Right.
Your Honor, he'll accept an adjudication of guilt.
All right, Mr. Clark, you understand that at this point, it doesn't matter what the state has offered you, the court is not accepting that agreement. You understand that?
What is the agreement again?
The state offered you something that the court is not accepting, so there is no agreement right now.
Okay.
So if you enter a plea of guilty or no contest, right now you're going to plead open to the court. That means I'll decide your sentence. I don't know what that will be. Do you understand that? Did we already swear him in? Please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Thank you.
All right, Mr. Clark, you had the opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights? You understand you're giving up the right to remain silent?
Yes.
You understand we're not going to have a jury trial here?
Yes.
Do you have any questions for me about the rights you're giving up? You understand if you're on probation anywhere, this plea could violate that?
Yes.
You understand if you're not a U.S. citizen, you could be deported?
Yes.
All right, sir, at this time, how do you wish to plead to the charge of disorderly conduct? You can plead guilty, not guilty, or no contest.
I don't know how I would feel about it because somebody was attacking a female and no officer was around to stop. So, yeah.
So what did you do?
The truth is, I seen him hitting her and then I got him off her. So I mean, according to the law, that's fighting. So, yeah.
Did you know this woman?
I don't personally have to know her to stand up for her. I just feel like no man should put their hands on a woman, especially violently.
I agree with you about that. Did you know the man?
I drew him a picture before.
I'm sorry, wait, you what?
I drew him a picture of him, a portrait of himself.
The law enforcement officer?
No, the so-called victim
Where did you draw a picture of him?
downtown.
But you didn't know him?
I don't know him personally. All I know is that I seen him before and I drew a picture for him. And then I seen him in a girl's face and I was like this. I went next to him. I was like, bro, calm down. And then he acted like he was calmed down. And then he just turned around and then snuck the girl. I was like, nah, bro.
You turned around and did what?
He hit the girl.
And at that time, did you touch him?
Not until after he hit the girl.
Right, after he hit the girl, then what did you do?
Punched him.
You punched him. Do you know when law enforcement came?
After he got off the wall, after being punched one time, he wrestled me and then he was on top of me. And then law enforcement got him off and then I was just relaxed after he was off me.
Do you know if law enforcement arrested him too?
I believe so. Yeah.
It says in the affidavit that there were multiple males fighting. Did you see any other men fighting?
I seen one other light-skinned person. Well, I was getting jumped because the light-skinned person had kicked me in the head while he was wrestling with me. So.
All right, sir, so how do you wish to plead to the charge of disorderly conduct? You have to pick a plea. It's either guilty, not guilty, or no contest.
No contest?
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. Sir, I have to order that you pay court costs, and I'll give you a year to pay those. Do you understand?
Yes, ma'am.
Good luck, sir. You have 30 days to appeal in writing.
I have 30 days for what?
To appeal. If you wanted to, if you thought that the judgment or sentence was illegal, you could appeal it, but you only have 30 days to do it.
Okay, thank you.
Good luck. Good morning. Please tell me your name.
Price.
Mr. Price, you're here in 21 MO 1360, charged with disorderly conduct. There is probable cause. Is there an offer in this case?
Yes, Your Honor. The offer from the state on the city's behalf is a withhold of adjudication, credit time served. I did speak to Mr. Price. We went over all the rights he would be giving up. He understands those rights and would like to accept the state's offer.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God?
I'm sorry, I didn't hear you. You have to answer out loud. Okay, thank you. Sorry, because we're making a record, even though I can see your head nod, the record won't reflect that. So that's why I had to ask you. All right, Mr. Price, you had the opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest today. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You understand that if you're on probation anywhere, this plea could violate that.
Yes, ma'am.
If you're not a U.S. citizen, you could be deported.
Yes, ma'am.
Sir, at this time, how do you wish to plead to the charge of disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. Sir, I have to order that you pay court costs, and I'll give you a year to pay those.
Yes, ma'am.
Good luck. You have 30 days to appeal in writing.
Andrew Mallon, bonded.
Okay. I don't have that one. Sir, please tell me your name.
Roberson.
You're here in 21 CT 7686, charged with no motorcycle license. You also have a violation of probation out of Polk County in 19-01721, based off this new charge. There is probable cause here. I'll appoint an attorney to represent you. Give me one moment. Because of the facts in the affidavit, the reason he's on probation, the fact that that's out of another county, sir, at this time, your bond on this will be $2,000. You can't drive in the state of Florida right now. Do you understand that?
I had a hardship license. I was only supposed to drive for business, which it was. I have a tow yard. Oh, I'm sorry.
At this time, I'm ordering that you can't drive. Your attorney's going to have to take that up in front of your trial judges. But on the violation of probation, you have no bond. So you're going to have to address that with your trial judge there. Good luck, sir. Please tell me your name.
Mackenzie Edwards.
All right, Mr. Edwards, you're here in 21 CF 14981. Give me one moment. Charged with possession of a firearm by a convicted felon, carrying a concealed firearm, possession of MDMA, and resisting an officer without violence. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is, just a moment. Your bond is $4,000 on count 1, $1,000 on count 2, $1,000 on count 3, and $500 on count 4. With special conditions, you can't possess a weapon of any kind, firearm or ammunition. You can't possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers or with the co-defendant in this case. Are there any other conditions the state would request?
No, Your Honor.
At this time, you also have a violation of probation out of Alachua County in 1800325. At this time, you'll have no bond on that. I'll appoint an attorney to represent you in that case as well, and we'll notify Alachua County that you're here. Good luck, sir.
Maximum is behavior.
Hold on 1 minute. 21 CF 15009. Ms. George, I'm going to appoint your office.
I'll waive the appearance, Your Honor.
Did you wish to be heard on this charge?
For PC purposes, no, Your Honor.
There is probable cause. Did you wish to be heard on bond?
I'm not sure. He wasn't able to be interviewed, and I'm not sure he's going to be able to be interviewed for mental health pretrial release, Your Honor. That would be the only thing.
Just looking at his record, his 8 prior failures to appear, 1 earlier this year, the fact that he has out-of-state history for being a deportable alien, actually has several of those, as well as a violent history. I'm concerned about his ties to the community, and this is not his first violent offense. At this time, I'll set his bond at $10,000 on this charge. He's not allowed to have contact with any victim or witness in the case, cannot possess a weapon of any kind, firearm or ammunition. I'll allow only a one-time return with law enforcement to the scene. All right.
I believe there was an allegation of alcohol, Your Honor.
All right, he can't possess or consume alcoholic beverages. Good morning, sir. Please tell me your name.
Michael McLeod.
Mr. McLeod, you're here in 21 CF 14982, charged with possession of cannabis greater than 20 grams, possession of MDMA, possession of a controlled substance, and resisting an officer without violence. I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard on any of these charges?
No, Your Honor.
There is probable cause. Your bond is $1,000 on count 1, $1,000 on count 2, $1,000 on count 3, $500 on count 4. With special conditions, you can't possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers or with the co-defendant in this case. Any other conditions the state would request?
No, Your Honor.
Good luck, sir.
Your Honor, he also has a.
Out of county.
You also have a violation of probation out of Alachua County. Thank you. In 1804303. At this time, you'll have no bond on that, and we'll notify them that you're here. Good luck, sir.
Case management is behavior.
21 CF 15010. I'll appoint your office, Ms. George.
I'll waive the appearance, Your Honor.
All right, there is probable cause. Give me one moment. I'll stay the bonds, $1,000 on count 1, $500 on count 2, $1,000 on count 3. Cannot possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers or any witnesses in the case. Or any victims in the case.
The state would also ask for a co-defendant as well, Your Honor.
No contact with any co-defendants. Not returned to the scene.
I believe it was at his residence, if I recall. Maybe the co-defendant's residence.
His or the co-defendant?
I believe it was the co-defendant, Your Honor.
All right, he can't go back there. The scene. Good morning, sir. Please tell me your name. You're here in 21 CF 15003, charged with fleeing or attempting to elude law enforcement. At this time, I'm going to appoint an attorney to represent you. Hold on one moment.
Your Honor, I would ask that you take into consideration he has no criminal history. And he does qualify for pretrial release, so I would ask for pretrial release in order to lower the monetary bond you're going to set in this case, given he has 0 failures to appear and no other convictions.
All right, what says the state?
The state believes the defense's request is reasonable, Your Honor. All the history that I'm seeing is driving related or open container.
What history?
I have an open container 2020, a Dwellis from 2012, a traffic Dwellis from 2008, possession of cannabis under 20, that was no pros from 2008. And then juvenile work structure that was withheld from 2005.
All right, sir, I'm going to place you on pretrial release and require that you post a monetary bond. However, I will reduce that amount significantly to $2,000 with special conditions. You can't drive without a valid Florida license. Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
Jason Rondo, bonded. Bruce Russell, bonded.
When did Roldos bond? Do you know?
It looks like he was released at 11:27.
Gotta be kidding me.
That's lucky.
Why didn't anybody catch that and change the bond on it? You know how sometimes we get like a bond correction form? Well, how come there wasn't one on that case?
You said it was 11:37?
27. We could have just brought him up this morning in the morning session. He's a violent felony offender of special concern. Why isn't there a hold on him? How could he have bonded out?
No, I believe that's due to the nature of the charge, but he's not on probation. He doesn't have any DOC history. That just populated because of the charges.
So they don't do the hold?
Not if he's not on probation, no.
So how come nobody did the bond correction form?
I guess due to being a warrant. I'm not too sure. That's inmate records. I'm not too sure.
All right, Miss May. I don't know if there's anything that can be done, but you're aware of it, so.
Other than the state filing a bond motion, I don't believe so at this point, Your Honor.
If you file it, we'll have the hearing right away.
Bruce Russell bonded. Datron Smith bonded. And Damian Avery.
Okay. Good morning, sir. Please tell me your name.
Miguel Taveras.
In this case, there's a bond correction form. In this case. You gotta be kidding me.
So, okay. So he was released because of the bond was on the warrant? Your Honor?
Yes.
Bond on the warrant.
But we have a department here that's constantly filing these things in these cases. Not that one.
Yes, Your Honor.
Super dangerous guy we didn't catch. This guy we did.
Right.
Sir, you're here in 21 CF 15000, charged with possession of cannabis with intent to sell or deliver with a weapon, possession of cannabis greater than 20 grams, and carrying a concealed firearm. I'm going to appoint an attorney to represent you in this case. Ms. George, did you have any arguments?
Yes, Your Honor. Stay just a moment with. Stand. Your Honor, as to the PC of the possession charge, yeah, my client was on the back seat of the vehicle. The items that were found, it appears, was in the front seat passengers on the.
And it was on the second row. It was directly in front where his feet would be within the vehicle.
Okay. I would just argue. Still, Your Honor, I would argue that I don't see anything that would indicate that he knew the items were there. It looks like it was in a bag. He removed the bag that was in the second row driver's side floorboard. And inside of that bag, there were items in a Chanel bag, as well as on the driver's side floor mat. There was a Glock that was found. My client was in the back seat. There's no indication that he knew the items were there. So I'd argue no constructive possession of the items. In addition, Your Honor, I would argue no possession with intent to sell with a weapon. I understand the amount that's there, but other than that amount, there's no indication that my client, I know they found the scales, but that my client was selling or delivering any type of drugs. Again, he's a passenger in the vehicle. There's no indication that he was the one that he knew there was the bag, that what was inside the bag, that he knew there was any drugs or weapon underneath the floor mat.
What says the state? Oh, I'm sorry. I thought you were done.
And if you do, however, Your Honor, find PC, I would just argue that I would just ask that you consider his record. It does not appear that he has any convictions here. He has some arrests, but no convictions, 0 failures to appear. So I just ask that you consider all of those factors.
What says the state?
Your Honor, state would argue that it's arguably not a constructive possession case. The firearm was located directly beneath the defendant's feet. When law enforcement asked him about it, it states that he said that he saw a co-defendant placing something under the floorboard. When asked again, he said he had no idea it was a gun, but stated that he felt the gun underneath his feet in the floorboard and knew it was a gun by the way the parts felt. In addition, the bag was directly between his feet when law enforcement found the bag with cannabis in it. I understand the defense counsel's argument regarding the intent to sell and deliver portion. I do believe PC is potentially more limited as to that, as there was a significant amount of 274 grams. However, I believe the $8,000 in different denominations was found on a different co-defendant, as well as any other indications of sale. So state would contend that there's PC for the possession of cannabis, potentially with a weapon, but not with intent to sell or deliver, and that there is PC for the concealed weapon, given the defendant's own testimony, as well as that it was directly beneath his feet and in between his feet.
Where was the scale? 2 scales were found. Where were those?
I'm not sure, Your Honor. I don't see it within the affidavit other than saying within the motor vehicle. So I'm unsure as to where exactly, given that there were approximately 1, 2, 3, 4, 5, 6, approximately like 6 or 7 people within this vehicle.
And then I see the feet.
The what?
That his feet, the gun was underneath his feet.
The gun was under his feet and the bag of drugs was between his feet.
Yes, Your Honor. In the, there. Mhm. Yes, Your Honor. I think it gets confusing because it says, upon a search of the motor vehicle, I observed the mail bag located on the second row driver's side floorboard.
That's where the defendant was allegedly sitting, according to the affidavit. Second row behind the driver's seat.
No, yeah, I see it. That's
It's difficult since there were like 7 people.
Well, thank you both. I appreciate the arguments. I do find that there's probable cause. I'll stay the bond at $7,500 on count 1.
Mm-hmm.
$1,000 on count 2, $1,000 on count 3. With special conditions, you can have no contact with any co-defendant or witness in this case. You can also have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. You can't possess a weapon of any kind, firearm or ammunition. You can't have any unsupervised contact with any minor child under the age of 18. Are there any other conditions the state would request?
No, Your Honor.
Your Honor, are you willing to treat the cannabis and the firearm as a subsidiary? Again, he has no other convictions here, 0 failures to appear. He lives in Melbourne, but still in Florida. He's been there for over a year. I'd ask that you consider all of those.
I'm looking at his arrest history. Couple that with the facts of this case. This is a really aggravated case. There are infants in a car with guns and drugs.
Again, Your Honor, I would argue that my client wasn't there was multiple people in the vehicle. He's disputing that any of these items were in fact his. So I just ask that you take all of this into consideration. And he does not have a history of possession of cannabis with intent to sell charges that he was arrested for. This appears to be his first time ever being arrested for these offenses.
Do you have the last page of the affidavit, Ms. May, that has the list of witnesses?
As of right now, I just have Florida as the victim, Your Honor. I don't have everyone listed.
Because you know how the last page usually lists everyone else who's involved?
Yes, Your Honor.
I don't have that.
Only place that I see everyone involved is the second paragraph of the affidavit.
Yeah. I see that. That's why I'm doing this, is I'm trying to place everyone in the car.
Yes, Your Honor.
I am not inclined to do that, Ms. George. However, I will reduce them both to $500 with all of the same conditions. Good luck, sir. 2 and 3, yes. Sorry, I changed that. Mr. Jones?
Yes, ma'am.
All right, you're back here in 21 MM 8234. That's the violation of injunction case.
Yes, Your Honor.
Ms. George, did you have any new arguments to make?
Your Honor, I would just ask that you again take into effect his history. He doesn't have a history of violating injunctions. And this, although he did go into the house, it does not appear that he did anything but take the phone and break it. I just ask that you consider the fact that this isn't an extremely violent offense, that the last battery DV case was from the same victim who decided not to go forward. I'd ask that you consider all of those things and the fact that my client is employed, 0 failures to appear. And if he was to be held here at no bond, he, one, can't work. So I just ask that you take all of that and the fact that he does not have a violent conviction history other than the arrest for the battery, domestic violence.
All right, thank you. Ms. May, anything from the state?
I don't have any additional arguments that weren't made previously, Your Honor.
I'm rereading the affidavit. Had it been arrested as a burglary with a battery, which it clearly is, we wouldn't even be having this discussion because on that offense, he's not entitled to bond.
Yes, which is, Your Honor, again, I would ask that you consider that the officer could have easily arrested him for that offense. He did not. He just charged him for the burglary of an occupied dwelling. So I just ask that you take all of those factors into consideration. And I believe if you set a bond amount in this case, as well as placing him on pretrial release, I think that would be sufficient, Your Honor, to
Does he
ensure.
qualify for pretrial release? We did.
They did.
In violation of a domestic violence injunction. Where does your client work, Ms. George?
I work at Chevy's by Millennium Mall, and I work at the finger licking, the licking by the Florida Mall.
What time do you work?
I work in the morning tomorrow.
What time?
What time? 8 o'clock
Until?
to 3, and then I go to my other job at 5
Until?
to close. We close at 12 on the weekends, and I think 10 on the weekdays. I just started at the licking. Only worked 1 day. I called the gym. I worked for Chevy's 3 weeks.
Do you have this order from the morning? No. Okay, thank you.
Your Honor, they don't live together or anything, so he has no reason to go back there. I believe that if you set the bond, I think this is a wake-up call, and given he doesn't have a history of these type of incidences of violating a domestic violence injunction, and he does appear to have a history of showing up for court, as he has 0 failures to appear, I'd ask that you set a bond in this case.
Aaron, did you have the opportunity to look at the petition for the?
No, do you have it?
I could print it. It's lengthy. It's 10 pages. The petitioner, the victim in this case, accounts a January 1st, 2021 event and the April 14th, 2021 event. The April 14th, 2021 event was the BAT DV case. It also notes that this has been happening since 2019 to the current year, 2021. I'm requesting for this injunction to assist my safety because my life is in jeopardy. He's assaulted me and he refuses to obey the judge, and no contact order was placed on him for 14/21. It accounts what happened on the January 1st and the April 14th incidences.
Can you print that?
The entire thing or just that page?
You said the 414, she
just that
said he failed
page.
to comply with the judge's orders in that case,
Yes,
which was the same one she decided to drop, correct?
I believe so.
She can't make that decision, counselor. Only the state can.
I'm printing it, Your Honor. It accounts that they got married November 27th, 2018. And it's been happening since 2019. Threats of what he would do to her until the current year. My internet's being incredibly slow, Your Honor. It's not coming up to print. Or what I am referring to is within the DR case, the affidavit.
What's that case number?
2021 DR 4979. It's the petition.
It doesn't come up that way. Is there something else? It doesn't come up for me. It might for you. Yeah. Give me the number again, counselor.
2021 DR 004979 AO.
It's the AO. Nope, that doesn't come up either.
On the clerk side, if you just search by name, David Jones, there are multiple David Joneses obviously within the clerk system, but if you scroll down to the 4979, that's how I found it, putting in the actual case number.
With just the O, it came up.
And what state was written from was the petition from 4/22/21. It's approximately 10 pages. I was reading from page 4, which is the victim's account.
I'm going to read the order as well. I'm reading the order. Respondent shall have no contact with the petitioner, shall not go within 500 feet of the residence. That language is really clear. I don't know how that judge could have been clearer. Mr. Jones, your attorney's made some really great arguments. I asked you about your work hours because I was considering giving you a bond and adding curfew conditions to your bond. But with the schedule that you gave me, you still managed to find time to go to your ex-wife's or your estranged wife's home. I read the injunction. That judge could not have been clearer in their orders to you. And yet, here you are.
My last time.
Mr. Jones, now's probably not a good time for you to speak.
Your Honor, I believe he said only one day, he goes to the second job. I believe if you implement the curfew, where he can only go to work and back home, and he's monitored by pretrial release services, I think that those conditions would eliminate his ability to go see her, or have time to see her if he can only go to and from work, as well as having him monitored by pretrial services.
Can you give me the order that I signed in the burglary case as well? I can get it right now in just a minute. (21 CF 15007). Ew. Wait, it's already here. I got it. I didn't know it was already uploaded. I'm gonna change that one too. Here's what I'm going to do, Mr. Jones. I'm going to add a condition in your felony case that you cannot be within 1,000 feet of the victim's residence or place of employment. That condition previously existed in the injunction. I want to be really clear with you today that if you violate my orders and you come back in front of me, I will most likely hold you at no bond. Do you understand that?
Yes, ma'am.
Is there anything about my orders today that's been confusing to you? Do you understand what no contact means?
Yes, ma'am.
Do you understand what it means that you cannot be within 1,000 feet of the victim's residence or place of employment?
Yes, ma'am.
Do you understand that if you're found doing those things, you can be held at no bond
Yes, ma'am.
for the duration of both of your cases? You understand that?
Yes, ma'am.
In the 21 MM 8234, I am going to place you on pretrial release and require that you post a monetary bond of $10,000. In that case, your conditions are you can have no contact whatsoever with the victim. You may not speak to her. You may not call her. You may not send a message through friends or family. You may not contact her on social media. You may not send a text message. Do you understand that? You cannot be within 1,000 feet of her residence or place of employment. You cannot possess a weapon of any kind, firearm, or ammunition.
Yes, ma'am.
You are allowed to leave your residence only for purposes of employment. You'll be monitored by pretrial release. You understand that? I don't know how to do a curfew if one day a week his job is till midnight. Oh, I could just, the curfew is, you can't do that. So we can't work that shift.
Yeah.
So you have to be in your residence until it's time to leave for work, and then you come back to your residence. You understand that? So you have to be, what time does your shift ends at 3 for your first job?
First job, and then the second one I go in at 5 or 4:30 or 5, because I got catch the bus to get there. So they don't give me a time limit to get there. And the latest I can get there is 5 o'clock. And on the weekdays, it closes at 10. But on the weekend, it closes at 12. So I can tell them to change my schedule up.
Yes,
Okay,
do that. Because you have to be back in your residence by 10:30?
10:30.
Can you get home by that time?
Yes, ma'am. Yes, ma'am.
You can catch the bus in time to get home by 10:30?
Call a ride or Uber.
What time do you get home when you ride the bus?
Like 11.
Does the bus run at 11? I don't know.
I like 11:30. Yeah, it runs.
Oh, that's really late.
Maybe I can get there. Using the bus, I can get there at 11:30. But Uber, I'll be there before 10:30.
11. You have to be in your residence at 11. Are there any other conditions the state would request?
No, Your Honor.
Good luck, Mr. Jones.
Thank you so much.
Yes, sir. Thank your attorney. Yes, he has to sign it in that one. He has to sign a no contact in both cases. Once he does that, we can go off the record.
You have to sign 2 more. He's not.
But does it have both case numbers on it? If it doesn't, he has to sign one in both cases.
They only have one.
It has to have both case numbers.
Say that. Say that.
Can I ask a question?
You can ask anything you want, but as I said earlier, everything you say is being recorded and can be used against you later. Do you understand that?
Yes, ma'am.
What's your question?
It's about the bond, all 3 of these, or and the 10,000, or is this the 10,000?
So that's just in the misdemeanor case. You still have the bond in the felony case that you have to post as well. So it's all of those bonds.
Adding up together?
Right. Added 1,000 feet. Okay.